And I'm excited. This is our first webinar we've done, you know, with the whole Merthyr Law estate planning team, rather than just one of us or two of us. And in this age of social isolation, we're all working from home, but we're still very much open for business. And, you know, one area that's really a focus for a lot of our clients is this estate planning. And so today's webinar, we're putting this on just a bit of an introduction of how do you organise that kind of estate plan in this era of social isolation, and, you know, how we go about that, how we're all working from home and still delivering the best legal services that, you know, you're used to. So, Steve, what's your experiences so far from the working from home dynamic?
Yeah, look, working from home, it's got its own nuances. It's great fun spending time with spouses and children and trying to do some work and things. But look, we've just got to do what we've got to do. In terms of today, COVID-19, though, has certainly been a reminder for a lot of people in terms of updating their wills and things. In the last couple of years, I've had a sister pass away and mum. My sister, when I was going through her stuff after she passed away, I found 3 wills that I'd sent her, all unsigned. So she passed away suddenly, and going through all the machinations of letters of administration for her was quite difficult, especially compared to mum, who passed away in January, who had a will. Just the differences there. So look, people have had a real focus. So I know we've got a couple of people online who did their wills 12 years ago, and their executors passed away 10 years ago, and they haven't updated their will until now. So again, a bit of a refocus across the board.
All right, well, let's introduce the team. So we've got everybody here. Melinda Ranson.
Hi everyone, how you going?
So Mel is our superstar warrior in estate planning. So she does a lot of that back end kind of work of when hopefully it's other people's wills, when their estate plan doesn't work out, and there's those family provision claims and those court applications and those kind of things that need to be done. But she still loves getting in the mix of, you know, seeing clients for some of that front end estate planning from time to time too, to keep that more civil dynamic.
Kieran, thanks.
Sorry?
Thanks for mentioning the website blurb.
Yeah, everybody check out our fun descriptions on the website. And we've also got Jacqui Pead with us. And so Jacqui is our Wills and Estates clerk, and she's currently studying her law degree and doing 2 law subjects this semester. And she's a bit dirty with me because today was her scheduled leave, and instead of doing her assignment, I'm making her talk to all of you guys in this webinar. So Jacqui, thank you for joining us on your day of leave. Sorry, we just unmute you.
There we go. Sorry, I think we unmuted each other. Hi, everybody.
And who else have we got here? Lauren Kettleton.
Morning, everyone.
So Lauren does a lot of our commercial work, but also gets involved in a bit of our estate planning, and she's talking to us today about some of those digital assets and, you know, that millennial kind of generation expertise that we need. We've also got Carol Taylor. Hey, Carol. So Carol is involved in all things estate planning. That's all she does is, you know, Jacqui or Carol often come along to the meetings with me and Steve. And these guys get everything done, the main face for the clients, and organise on that other side too, when people pass away, you know, looking after the administration of that estate and that side of things. But more importantly for everyone today is Carol is the judge and arbiter of the prize. And so, you know, before I said, please ask questions and give us feedback. Well, Carol is the hander-outerer and the final decider of who gets the bottle of wine. And we've got some really nice champagne, white wine, red wine, depending on what your preference is, that we're awarding to the best question of the day. So Carol, a big job on your hands, and your decision is final and binding and not appealable. So, Carol, it's a bit of a starter, I guess. You know, people today, some people who are watching have already got their wills sorted, but what about those people who have been putting it off? And this time for, you know, this COVID-19, this pandemic, is prompting them, oh, geez, I'm actually going to put my finger out and get that sorted. How do they go about doing that?
Yeah, so if you get in touch with us, we can arrange a meeting with you via Zoom because of the current restrictions on meeting. And we conduct those meetings very similarly to how we would if we were meeting with you in person. We take some time to get to know you and learn about your family dynamics and relationships so that we can really tailor your estate plan to your particular needs. And we'll also get some information about what you own, your investments, real estate, superannuation, how you run your business if you're a business owner, and also, life insurance. And from there, we have a chat about your wishes so that we can structure your will as you would like, and obviously give you the necessary warnings and advice, and try and structure it in the best possible way. We also look at other documents apart from your will, like your enduring power of attorney and advance health directive, binding nominations for your super, so that we're giving you a complete estate plan.
Yeah, and so, Carol, I guess, one advantage of doing it via Zoom, in this age of social isolation and distancing, is, people don't have to make that trip into town. They can give us instructions from the comfort of their own home. And you and me were involved in a Zoom with an 84-year-old. First time on Zoom, organised it all himself, and he did a really, really stellar job, and, pretty handy. And we'll go into some details of, how that exactly works a bit later in the chat today. But Carol, what about that instance that I referred to before, where people don't have a will at all? What happens then?
Yeah, so if you don't have a will, in Queensland, our Succession Act governs that your estate will be distributed according to the rules of intestacy. Now, some people might not be aware of what that means for your particular family. If you have a spouse and children, that can mean that your spouse is not getting your entire estate, that they will be getting only the first $150,000 of your estate plus your household contents. And then they'll be sharing the balance of your estate with your children, which, may not be what you would like to happen.
Yeah, so that can be a, it can be quite confronting, I guess, for, when I talk to clients and say, well, if you die without a will, you're sharing your house with your kids. Often that's not ideal for those spouses. So, that's a pretty big inspiration for them to actually get something on paper and get it sorted. Much better than having those rules dictated for you and, you having to share your assets with your kids, so to speak. Which brings us to, and I'll ask you now, Steve, I guess we see a lot of clients, and one of the biggest decisions for clients to make are those important appointments under their will. And, what's involved in making those appointments, who to appoint as executor, who to appoint as guardian of the kids, who to appoint as that trustee for a longer time. And what's your advice there, mate?
So look, typically in most wills, mum will appoint dad and dad will appoint mum to be the executor in their wills. And then typically, if mum and dad have both passed away, you'll appoint your children to be the executors. You can only have a maximum of 4, so that seems to cater for most families. But if you've got 5 or 6 children, then again, you can just pick the 4 that you think will be best in that job. Or alternatively, you can just pick 1 if you think they're going to be particularly good. The problem obviously is where mum and dad are young and have young children, you can't have 5 and 6-year-olds being executors, so you have to look into your family and see who would that be, that ideal person, We're looking for the ideal trustee, the perfect trustee, someone like you, Kieran. No. But look, we're looking for someone who's going to be an ideal mentor. Perhaps it's going to be a sibling, perhaps it's going to be a parent. And I think we always say to people, don't be worried about age of the executor. If you were going to pass away tomorrow, if you were going to be hit by the omnibus, then look, that person's going to be the ideal person to be executor tomorrow. If things change, you can change that executor down the track. We're always thinking...
What about, Steve, I know there's been some cases we've been involved in where an estate administration has gone on for like 5 years or so because all of the children have been appointed co-executors and they all hated each other and spent a lot of money on fighting lawyers. What's your experience there?
Yeah, look, we had a dreadful example where there were 5 children and none of them got on, 4 of them were executors. and they went on for 12 months just to get the probate, so just to register the will at the court. They spent that sort of time and over $100,000 in fighting. So if you know your children best, if they get on well, you can appoint multiple children to be executors. If they don't get on, then you need to consider appointing someone who's independent to take on that role, or perhaps just one of the children so decisions are made. If you've got a situation where you've got 4 children, you might want to build in some dispute resolution between the trustees into your actual executors. You might say majority decisions, or you might put in someone who's going to make a decision if we're at a dead heat on something. Yeah,
good idea. And what about if you are appointing that independent or that professional, you know, what does that look like as far as fees and charging?
Yeah, look, if you appoint a friend, obviously they're typically not going to charge, particularly if it's a close relative. If you're appointing, often we're asked to do the job as a lawyer, and you know, we are entitled to charge a fee. So there's going to be a cost there. If you appoint perpetual trustee, they're going to take up to 4% of the estate initially just to take the appointment, and then they'll have an ongoing fee of maybe 1.5% of the capital of the estate going on, or a part of income. So typically, if we were going to be appointed, we'd warn you about that cost and say, hey, is there a relative that might do it for free? We wouldn't charge commission, but relatives that you might appoint might be entitled to charge commission. So you need to sort that out with them. Once again, you know, having a frank discussion with the person you're going to appoint as executor about whether they're going to charge or not, what the job's going to entail, is a good idea up front.
Steve, I've just got a question that's come in just while you're talking about independent executors. And it is, how often do you recommend using an independent party as at least one executor, and under what circumstances?
So look, typically, particularly where we're doing testamentary trust wills and we're looking for that family law protection for the children, we need to have an independent trustee with our child. So if there's a breakup of their marriage in the family court, we can say genuinely to the family court that that trust is not controlled by the party to the marriage, that it's in the hands of an independent trustee. So that might be a family member, typically not a sibling of the person that's involved, but you know, it might be the family accountant, might be the family financial planner, might be their lawyer, or just someone that they trust who'd be good in that role. So typically you want an independent trustee where children don't get on, or where the children are too young, or where you're looking for that extra family law protection under a testamentary trust.
Yeah, and most time, obviously, the spouse is the natural executor for, you know, that first instance, and so you're talking that next level where, you know, both of the spouses have passed away. But Steve, you mentioned there, you know, your testamentary trusts, and you know that appointment can go on for some time. It's something that we are constantly educating our clients on, you know, banging on about these testamentary trusts. You know, what are they, and you know, what are typically the advantages for those people who might be listening to that?
Look, testamentary trusts try to simulate a simple will, but they're building in some added protection. The first one is just family law protection for the surviving spouse. So if you're in your 60s and your spouse passes away, just say dad passes away, mum's left, she's in her 50s and 60s, she's down at the local gym and she falls in love with the 25-year-old gym instructor who's lucky enough to have a few children from his first marriage. Do you want those assets that have passed into you know, your estate to now be subject to an attack by that partner should they now leave? So it's sort of one way of protecting yourself against new partners should one of you pass away. But probably more importantly and more relevantly, when you've both gone, if there's a testamentary trust and you have 3 or 4 children, then that divorce rate for de factos and married couples is around 40%. So if you have 4 children, you're going to have 2 divorces. Typically that son-in-law and daughter-in-law, you don't want them to leave with half of your child's inheritance. So testamentary trust is a way of protecting that inheritance. So your child hangs on to it and your grandchildren hang on to it and your great-grandchildren, rather than leaving the family through an ex-spouse. Also, we use them at the moment. We've got an estate, an elderly lady, she's been widowed, she's 5 children, but 2 of her children are bankrupt currently. So we have to change her will and have the testamentary trust to protect the inheritance of those 2 children, because we don't want it to go to the children's creditors. We want it to actually go to them for their benefit.
Steve, we just had another question that's come in about testamentary trust wills, and it's just asking how adult children access the money if a testamentary trust has been set up.
Okay, so typically the trustee of the testamentary trust is going to be the child and the independent trustee or the child. So the child will be making decisions about when they access the money. They'll be able to make a decision. Hey, I need $100,000. I'm doing some renovations at home. Now, whether that's lent by the testamentary trust to the child or whether it's an outright distribution, that's something you can take on advice at the time. But having a testamentary trust and receiving the inheritance directly under a simple will, you should be able to access the money directly, but the legalities of that will be done slightly differently, but the access will be the same.
And Steve, that's one of the real advantages of these testamentary trusts, I guess, is that they can last for up to 80 years from when they're created. So that's, you know, when the testator passes away. And that can also mean, instead of under a simple will, that those kids who have lost both of their parents and, you know, are, might be a bit messed up because of that, instead of them getting this massive inheritance when they're 18 and making some mistakes with that could possibly harm them, you can have more flexibility built in there. So you've got that independent trustee who only hands over those reins, you know, at a certain age recommended by the testator, only when they're satisfied that the kids are stable in their relationships and are financially responsible enough to handle, you know, that kind of inheritance. Also, Steve, the last advantage, I guess, that kind of selfless advantage, is it's one of the best tax structures that you can leave your loved ones. How does that work?
So with a testamentary trust, when it's producing income, you've got flexibility about who receives that income. So if mum and dad were in their 70s when they passed away and their child is in their 40s and, you know, earning good income and on a higher marginal rate of tax, and they've got a 5-year-old child, rather than taking that $10,000 in income themselves and perhaps paying tax at 30% or 40%, you can distribute that income to your child. Now, they're entitled under a testamentary trust to receive $18,000 per annum per child, tax-free. So that $10,000 of income will be tax-free in your child's hand. So you've got that tax-free money now to be paying for school fees, to be paying for their computers, to be paying for their school trips, to be paying for the groceries that we use for the kids, for paying for their holidays and all those types of things. And remember, it's $18,000 per child. So if you have 3 children, you can receive almost $60,000 a year tax-free for those important things like school fees and the like. So it's a great advantage, and that's going to continue until that child is 18. And it can also keep going for the next generation for your grandchildren and your great-grandchildren.
Oh, Steve, just another question that's come in. Sorry, Kieran. It's just about, if money has been distributed from a testamentary trust, could the partner of the beneficiary get access to that money if there is a split?
Yeah, so just when I mentioned before about whether we make a distribution from the testamentary trust, which means it's then absolutely the child's money, then that will fall into the asset pool and can be taken by a partner. So where we think the marriage is not stable or we're trying to do the best asset protection wise, what we'll do is we'll suggest that the testamentary trust loans the money to the beneficiary, to your child. So that loan has to be repaid if there's a marriage breakdown. So that's a good tactic. And again, we're just protecting the inheritance that mum and dad have left behind. We're not trying to affect the money of the parties to the marriage.
So there's really a lot to unpack in, you know, all the intricacies of the design of testamentary trust, their advantages and what's involved. And it's something that we could talk, you know, for a 5-hour webinar on. So we're really just kind of touching the surface today. I'll just share this screen with you for a minute. We've done quite a few animations and different videos and packaged those up on our Merthyr Law YouTube site in a little playlist there. So if you want more information of how these work and some humorous kind of animations that the team have done up, that's where you can find it, Merthyr Law YouTube there. So, you know, worth having a bit of an explore, I guess. Now, I guess we've been talking a lot about designing your will for looking after your loved ones, typically your children. But we have a lot of clients who, you know, they might be in their 50s or, you know, being pretty successful. And quite often they've engineered some asset protection, so they might own no assets in their own name. But then their parents, their elderly parents, have just got a simple will in place. And, you know, I know it's a first world problem, but it ruins all their asset protection when that child who's an at-risk director or business owner or whatever receives a $1 million inheritance. So part of your thought of your estate planning isn't just designing your will, it's kind of making sure, you know, those kind of contingencies, that your parents' will talks to your will, that your will talks to your children's will, and all of that kind of complements each other. And one thing we've been doing a bit of over the last few years is, you know, when I first started as an article clerk with Steve in 2002, a long time ago, you know, we had a few of those kind of more old school clients where it was, you know, the husband would dictate what the terms of the will were, and, you know, the family would be surprised when, you know, it was read out to them when they died. And that's really quite a outdated method now. What most of our clients are doing now is, you know, they want to minimize that chance of dispute. And so how do they do that is they have an open dialogue. So, you know, they talk to their children, hey, this is why I set up testamentary trusts. This is why I appointed Steve as a co-executive, a co-trustee of that testamentary trust for a few years, so you can, you know, make sure the inheritance is protected for you. This is why I made these appointments of these executors. And the idea there being is, well, if the kids have all been around the table with the parents and possibly the lawyer, and, you know, they've had an open discussion, well, you know, they're not really entitled to get their nose out of joint once the parents have died. And I was recently involved in one over Zoom, and so it felt like it was part of the family Easter lunch, because we, because of social distancing, had to do this family estate planning forum over Zoom. And it was like a bit more personable straight away, because with Zoom, I was invited into each one of those kids' own homes, and, you know, they're kind of kids in the background and that kind of thing. So I think it's not just a set and forget. It's not just doing the documents, it's having those conversations and you know, making sure that all the estate plans all talk to each other. Now, obviously, I'm for those who don't know me, I specialise in self-managed super funds. And, you know, there's all kinds of rules and regulations with respect to that. I could, again, talk for hours on all of those rules. But the main takeaway is, well, your super doesn't form part of your estate. So you do a will up, it doesn't have anything to do with your super. So you just got to be careful there. Another thing that a lot of clients, I guess, might need to revisit their estate planning with too is all of those big changes in 2017, where you can only keep 1.6 million. Steve's on the beach, hello. It's checked out, he's on the beach. Where's that, Lennox? And, oh, where was I? Sorry, I've just been distracted there. And yeah, so with that 1.6 million, you've got to take that out of super, whatever's over that $1.6 million amount now. So a lot of estate plans have to be revisited with respect to their will, making sure they're dealing with that super correctly. You know, the best way is making sure we have those testamentary trusts set up, not on the death of both spouses, but on the death of that first spouse. And there's, you know, a part of our estate planning process is going through, if you have a self-managed super fund, going through making sure you're aware of, you know, who's going to take over control of that, and it's being passed on appropriately. If you're a public offer fund, just making sure that you're aware of what those tax consequences are, depending who you give your super to, so you're making those informed choices rather than leaving behind a, you know, possible bun fight. So, you know, that's my super side of things. And so we've invited Lauren Kettleton along as the token millennial. And the question we've got for Lauren, I guess, is, you know, digital assets. What are these digital assets? And, you know, is it something that people should be turning their attention to under their wills?
So digital assets includes a wide range of different items. So it's got your typical ones like Facebook, Instagram, LinkedIn, Snapchat, or your email accounts. But then there's also the streaming subscriptions that you have to take into account too. So Netflix, Spotify, content hosting accounts with services such as OneDrive, all your rewards points with Flybuys, frequent flyers, Woolworths rewards. And then you could also have cryptocurrencies such as Bitcoin. So some of these are free, but some have monthly fees attached to them, and some are of value. So you don't want to forget about them as part of your estate plan. So one option is to have a list of all your digital assets. You could include this in a letter of wishes that we can keep with your will, or you can keep it with your file so you can update it regularly. If it's at home, just make sure your executor knows where it is. A list means your executor knows where to start, what companies to contact to organise access to your accounts, what subscriptions to cancel, and what accounts to keep an eye out for so that they can cash in those rewards points. Another option is to use a password management system that stores encrypted passwords online. These providers usually let you set an emergency contact as well, and that person's able to access your account once you pass away. Once they're given access, your emergency contact can then deal with your accounts in accordance with your wishes. Social media accounts as well have the option normally to memorialise your account or to delete it once you pass away. Facebook, for example, lets you set a preference while you're alive on whether you want to memorialise or delete your account. And if it's memorialised, your friends and family are able to share memories on your timeline after you've passed away. So digital assets aren't always the assets with the most value, but it can be a logistical nightmare for your executor if they don't know where to start. So it's important to have a think about it as part of your estate planning.
Yeah, so Lauren, I guess, you know, I was reading a case a few months ago where one person died and apparently he had $300 million worth of Bitcoin on his laptop and no one could get at it. Sounds a bit dodgy to me, but you know, you do hear of those kind of stories where, you know, those kind of digital assets, you don't tell anyone how to access that key that's stuck in your computer. Well, it's just gone into the ether. So, you know, you like those, you watch those documentaries on Pablo Escobar and the piles of cash that are lost for forever, you know, that they're buried underground. But even on a more personal level, like what about, you know, most of your photos now are all digital. So it's really important that you've got a mud map for your loved ones to be able to access those photos so they're not lost forever, you know, whether that's your wedding photos, your photos on your phone, of your kids, of your iCloud account, having a bit of a plan in place for that. And, you know, you don't want to be giving your passwords for everything out and getting hacked, but having a plan of what the best way of doing that is. Thanks, Lauren.
And just before we move on that one, sorry, Kieran, I mentioned before my sister passed away a couple of years ago suddenly, and one of the things that we had great difficulty was opening up her phone, an Apple iPhone, trying to find the password to that to access her emails. And of course her laptop, it was only by luck that we were able to find the password for that. My father guessed a few different passwords and was able to get through. So really important that those passwords are left somewhere for someone to be able to find after your death, to be able to access all your information and be able to put your assets and liabilities together.
Yeah, definitely. Mel, I guess moving on, now we've been talking today about, you know, people coming in with capacity, whether it's via Zoom or whatever, and doing their wills. What about where people do not have capacity to do a will? Is that the end of the story for them, or what options might be available if you've got parents or loved ones who can't make a will but should?
Luckily, we do actually have an answer to that question. We can, in some circumstances, apply to the court for the court to make a will for a person who's lost capacity, for a person who didn't have capacity in the first place, and also for a minor if there's good reason, if they, for example, if they've been through some sort of accident and they've got a fairly large amount being held by the public trustee or something like that, and we want to deal with how that large asset is going to devolve if they were to pass away early. For most of our clients, though, it is going to be more typically a situation where the person is mum or dad or a family member who's lost capacity, might have previously had a will, might not have, but something in their circumstances has changed that means that that will is no longer appropriate. For example, a couple of years ago, Merthyr Law had a client who came where mum had dementia in a nursing home and wasn't really able to communicate, but her son was about to go through a divorce. And under her will, he was to receive his inheritance personally. And as we've been talking about, Steve was talking about just earlier in our discussion, there was the potential for that to be lost to the spouse if mum did pass away before a new will was made. And the court accepted that there was lots of good evidence around that mum would have changed her will in that situation to add a testamentary trust in. So it's a very flexible system that the court has come up with. It's been around for about 15 years now, and it's been used quite successfully to help with a lot of estate planning situations, to make sure that circumstances don't just run away with us and we can still respond.
And it's an important topic for everyone listening today, is planning not just for dying as part of your estate planning, but planning for, hey, if you lose capacity and you can't make decisions for yourself, who are those loved ones that you can appoint and to make those decisions kind of on your behalf there. They can't make a will for you. You've got to go see Mel and go off to court for that. But
and it's a hard process, let me tell you.
But you can save a lot of heartache by doing these other documents that avoids having to go to court to take control of someone's affairs. Jacqui, tell us about their options there.
Yeah, so they can do what's called an enduring power of attorney. So that's a pretty important document in your estate planning that lets you appoint an attorney to make decisions on your behalf where you've lost capacity. So normally you would appoint your spouse as your attorney or a close family friend. We normally recommend where you're appointing your spouse that you let the power for financial matters start immediately. That just allows your spouse more flexibility when they need to, say, go to the bank to get things signed. They don't actually have to go to a doctor first, two doctors first, to get their assessment of you done. And then, as well as an enduring power of attorney, we have what's called an advance health directive. So this records your wishes for your future medical care. It's good guidance for your children if you think that they might not want to follow your wishes. And also, if you are diagnosed with a terminal illness, it just means that you can say what you want to happen to you in the future.
Yeah, so Jacqui, we've seen some situations, I think, where those advanced health directives really come into play is those advanced health directives is where, like the parents being widowed. And so it is exactly that. It's those adult children making those decisions. And we've seen instances where the 3 kids have been appointed as those health attorneys. And then one kid is like, oh, look, we've got to do everything we can to keep dad alive. And, that's invasive surgery. And what has ended up happening, what we've seen, is that their dad, instead of, dying peacefully, at the right time, has been kept alive for another 3 years, but not a very good standard of living, in that hospital, fading away, and, the memories of a much weaker kind of parent. And I guess it's a big decision to put on those kids. And so doing that advanced health directive can, take that pressure off those kids. For me, I don't have one. I'm happy that my wife, Erin, will make the right decision in those circumstances. I think she'll be pulling that plug pretty quickly. But, where I think they do come into play is that other instance, where you might not have that spouse who will intuitively make that right decision. And how do they go about getting one of those advanced health directives in place, Jacqui?
So you actually have to go and see a doctor and have it done with them before you can come back to us and have it witnessed. So the doctor will go through all the questions with you, make sure you understand everything before you can have it witnessed.
Yeah, and I thought that with the COVID-19 pandemic that, you struggled to get an appointment with a GP, and that might have been the case a month ago when it was first happening, but the feedback from clients now is they're getting into the GP okay, so, they can still be done if that's a priority. So, Jacqui, I guess the logistics of, we're all here today in our own homes, following the government's guidelines to, not be at work. But we're still very much open for business, and we've been as busy as ever, and a lot of that doing the estate planning. So just like to show you, what kind of options there are for the estate planning. And one of those is there's types of people who like to do that homework beforehand. And, for those kind of people, well, we've got a solution online so they can get straight into business and they can give us a really solid brief before that meeting. And I'll just share my screen here. So this is just our website here, and sorry, I have gone too far. I've already gone into it. So, this is our website, everybody. If you haven't seen it before, we've got, funny clown faces and all kinds of stories, and, look at who our people are and our funny names we've got for all of us there. But what am I actually looking for, I'm sorry, is doing your estate planning online. So whether it's clicking here or clicking, your wills online or your family law online. So, Jacqui, tell us what's involved with that.
Yeah, so if you just go to that link on the website, you can complete a lot of the details that we would get from you in that initial meeting. So just family history, like your family tree, your wishes that you want in the documents, and it just gives us some background so we're prepared for when we first meet with you or speak with you over the phone.
And what we're finding too is sometimes it's the advisors that are, getting their clients to come and see us, and they're preparing that for their clients. So we're already briefed, and we can get, what that means is we're not spending the first half hour of that meeting doing data collection, which, sometimes, people don't know exactly what entities they own things in and that kind of thing. So that can take up a bit of time. It means when we meet, we can talk right about, get straight into it and talk about what's suitable for your estate planning needs, what your priorities are, and really talk through those issues rather than that data collection. It can even help, some people are even doing it for their parents. Of course, we've still got to get those instructions from the actual testator, but it can really give us that good head start of what their position is. And it gives us a really concise and good, summary that, both you and Merthyr Law have with, what's important to you, what your family relationships are, your executors, and those assets and liabilities. So we can really hit the ground running. But not everyone likes to do that homework. So, of course, if you're not the type of person who likes to fill in those online questionnaires, that's fine. You can give us some financials and that kind of stuff beforehand, or we can get that information off you that old-fashioned way, just having a chat and, instead of you having to fill out that paperwork or do those questionnaires. So, don't think that you've got to do all this homework before you can start that process. Just stop this share. We're on Zoom webinars today. For those who haven't had those Zoom meetings with us, they're really easy. We send the link through. You can do it via your phone or even better on your computer, as long as it's got that video and audio. So those laptops are good. And like I said, Carol and I have done it with 84-year-olds who have done just fine with it. We can even go through all of those meetings now, and you don't even need to leave your own house. So it's saving that hassle of coming into town, and certainly giving a lot of people that peace of mind that they're not putting them or their loved ones at risk by having that unnecessary social exposure in this time of COVID-19. Having said that, there are still people who, still want to come in, and especially for those will signings and that type of thing. And the office is still open. We've still got, a person coming in every day and, checking the mail and doing those kind of things, and solicitors from time to time coming into the office. So, we still can see people and keep that 1.5 metre social distancing. And I know my kids are quite noisy in the background on Mondays to Wednesdays, so sometimes I'll be going into the office to kind of, make sure I don't have that noise in the background of those kind of Zoom chats, etc. As far as costings for your estate planning is, we offer a service where that initial meeting, where we go through all your stuff, we have that chat and we make that recommendation about what's right for you. We're happy to do that for $300 plus a GST. So, not much at all to get, years of experience on that, typically for those kind of qualified clients. And then we give you a fixed price quote from that meeting, that we stick to, that is, this is the price for, implementing whatever that recommendation has been. And that can vary depending on your complexity. So, a couple of simple wills, for a family, some advanced health directives or with enduring power of attorney, etc. That might be, I don't know, around $1,000, $1,500 level. Whereas your complete estate planning with some, complicated children from prior relationships and some complicated super planning and dealing with, some really complicated scenarios and some trustee plannings, that might be north of $5,000, for some of those ones. And anywhere kind of in between there. But we really do, and we take it seriously that when we give you a quote for any of your estate planning stuff, we stick with that. So, you know, you can rest assured for you or anyone else that, you know, that we take that very seriously at Merthyr Law, sticking to those fixed fees. So, you know, that was kind of, I guess, getting those instructions for doing your wills in this time of social isolation. But then what about the legality? So if you are stuck at home, can you sign a will validly? And can we do that via Zoom? Can you enter an enduring power of attorney remotely via a video conference? And we've been involved in a few where we've done this in the last couple of weeks. And Mel, we've done a couple. What's been the status there in your experience?
Yeah, so we have done a couple in the last few weeks, and it comes back to, as you say, trying to be as business as usual. And the law is trying to catch up to allow some flexibility and understanding that people don't want to leave their houses at the moment, and trying to give some other options to make sure your will is actually in place at this point. At the moment, it's still a valid will if you have two people present in the room with you. But if you are unable to do that, we can set up a video conference with you, record the meeting, and have the witnessing done remotely. And there has been some recent practice directions and legislation coming out from the government allowing that process not to be a valid will so much. It will be an informal will, but allowing a quick and easy process to get that informal will signed by video conference through the court system, almost the same as if it was a normal probate application. It's important that there's a couple of, obviously there's always going to be a couple of criteria to allow that will to go through as easily as possible. Including that you have a lawyer or make the will or witness the will with you. The reason that you can't leave is because of the COVID-19 issues. But generally it's going, you know, we've done it, as Kieran said, a couple of times now, and it's a relatively straightforward process for us to get that Zoom meeting set up for you and make sure your will is still in place in this time. And the clients who have done it, it's really been a weight off their shoulders because they want to have their estate planning sorted, and you know they get that cathartic effect of going, okay, well at least I've ticked that box now, but they don't want to put themselves at risk by going into town or seeing the solicitor's office. So that's it's a good adaptation to our current climate, and hopefully some of these changes might stick at the end of it. Maybe they go, well, you know what, that wasn't too bad. Why don't we let wills be signed digitally or over video conference or those kinds of things? I know with the self-managed super fund for binding nominations, well, it all depends on what your deed says. So if your deed says it's got to be in the presence of 2 witnesses, well, that's what you need. What you can do is change your superannuation deed though. And usually you only need the trustee to sign that without a witness or, without a legal witness anyway. And so change that trust deed and then you can do a binding nomination without witnesses or via video conference. What about enduring powers of attorney, Mel? Where are we up to there? Yeah, unfortunately, the situation is a bit different with enduring powers of attorney because they need to be witnessed by a qualified witness, which is either a lawyer or a JP. The law still requires you to be in the presence of, meaning in the same room as that qualified witness. So while it might be nice to have seen the person sign their enduring power of attorney over video, that one is not going to be 100% valid under the regulations just yet. But luckily we are anticipating, or at least hoping, that the Queensland government will come through with some regulations to allow those electronic signing of the enduring powers of attorney to become a valid power of attorney. Unfortunately, it's not in place just yet. We are just going to have to watch this space and see what we are allowed to do in the next week or so. Hopefully those regulations will come out. Yeah, so they just a couple of days ago, they passed legislation, COVID-19 legislation, and one of the areas that the government's allowed to put regulations through, and that's without passing Parliament and that kind of thing, is rules with respect to the signing and witnessing of documents. So all of those rules that, the solicitor or the JP's got to be in the same room, hopefully, those regulations will come into place. And what we've been seeing so far is often they're backdated to, March and the start of this kind of lockdown and this
crisis. And so Mel, you know, we've even done that for one of our clients, is we've said, look, this isn't binding where we are right now, but how about you sign it up and we'll put that, you know, special clause saying we weren't in the same room, but we're on the video together. And once they put that regulation out, hopefully that's valid then.
And as soon as we're out of this, we'll fix it up and get on to making sure it is valid.
Yeah, and so, you know, I've been busy, you know, trying to make sure Merthyr Law is ready for the digital age for a while, and this COVID-19 crisis and everyone working from home really kind of quickened that pace of change up. And hopefully there'll be some really good legislation that allows us to keep doing these online meetings and that kind of stuff, because a lot of it's making life simpler for people, and you know, it's not creating any extra risks. So hopefully there should be some good things, I hope, that come out of, you know, this lockdown and this crisis. Did
you anticipate any of this in your Journey 2020, Kieran?
That's why I called it Journey 2020, Mel, because we're arriving and we've arrived and everyone next to a jobs right now. If only I had that same foresight with my shares. So today we've been talking about getting your wills done and starting that process. And taking a look at do it. Steve, what about those do-it-yourself wills, those post office wills, those kind of things? Have we done it?
Do-it-yourself wills are my favourites, of course, because that's how we make the most money. You know, I can do an oil change on my car, and instead of it taking 10 minutes, it'll take 4 hours because they don't do it all the time. But, you know, the post office wills, sometimes they're free, or you pay a couple of bucks for them. And of course, they're in the right format and all the rest of it. It's just the words that are used. And of course, most people don't know the difference of whether they own an asset personally, or they say, hey, I own that house and it's owned by a trust. Or they say, hey, I own that share portfolio and it's actually in a leveraged equities type situation, and it's owned by a company. So, yeah, this is part of the difficulties. This is the stuff that we're used to dealing with. The best example, most recently, I had 2 senior university lecturers in their late 60s. Both of them had been married 3 times and had had kids from their first marriages. They'd recently got together about 3 years ago. One was an American resident. The other one was an Aussie lady. And they'd done their own wills with an estate somewhere around about $14 million between the two of them. And again, they asked us to read it, and I said, look, these are the problems with it. But they seemed quite content that it carried out their testamentary intentions, and all I could see was being a big money spinner. Their kids were quite unaware of it. So much of their income was in superannuation that they had accrued when they'd been at different universities. So again, everyone that we're talking to today specialises in something, whether you're an accountant, whether you're a financial planner, whether you work as a shop attendant, whether you work at something, everyone specialises in something, and you're better off talking to the specialist so they get it right, carry out your intentions, rather than having an amateurist crack at it and just generating money for lawyers.
Yeah, and one of the big ones is we're seeing your family provision plans all the time, Steve and Mel, and that's where you leave everything to one kid, or you leave someone out who is part of that group of the spouse or kids that the court thinks you have a moral obligation to, and then Mel's busy, and we make a lot more money off those litigation files than we do off those will files. And perhaps if you met with a lawyer, we could have raised that possibility, and we could have come up with some plans of how to try to minimise the risk of such a family provision claim. Another area too that wills get challenged is on grounds of capacity. So did you know what you owned, what your moral obligations were, what a will was? And we convey all that stuff when we're having a chat with our clients in a friendly kind of manner. And so it doesn't seem like we're doing a test when we're doing that. We're just having a chat. But all of that is you've got those notes from a solicitor proving that you've got capacity. So it's making that will less able to be subject to challenge through that lack of capacity. And even better now, like if we're doing it on a Zoom meeting, we can even record that. So, if there ever was any question that, the parents meant to cut this sum out or they overlooked something, we can get that video out and have that real proof of it. So I guess, do-it-yourself wills, go for them if, but it might be a bit more expensive in the long run. So look, I think that wraps up the formalities of today. We've left a little bit of time for questions at the end. And of course, there has been some good questions asked today, and so the very important decision by Carol of who gets that prize. Carol, we got any questions there?
There's a few questions that we haven't gotten to yet, Kieran. The first one is to you, a super question. It's just asking if you have over 1.6 million in super, can you take it out and put it into another fund if you wish to?
No. So you can't put after-tax contributions into super if, so those non-concessional contributions, if your total super balance of all your super funds is over 1.6 million. Now, where a lot of clients are visiting us again is we might have a client who their members balance is $3 million. In the old days, that just, if they were, you know, of pension age, they'd leave all of that as a tax-free pension to their spouse. And so you've got all this money inside a super that you're paying no tax on, and the spouse is paying no tax on receiving it. And the government said, hey, you know, fair's fair, like $1.6 million should be enough for you. So whatever's over that, or what's, you know, that 1.6 that started on 2017, that's got to come out of the system and either get paid to the spouse individually or to your estate and can't be put back into super. So, you know, anyone in that situation should be revisiting their wills and making sure that their wills deal with that super properly, so they're not paying that death benefits tax and, you know, it's adequately dealing with that via testamentary trusts or otherwise. Thanks, Ben.
Now, there's another question here for Steve, just about testamentary trust. And it's asking if a will was, say, 20 years old and it established a testamentary trust, and then the testator passes away without updating that document. Can that trust deed contained within the will be updated to account for changes that have happened in the law?
Hi, David. Look, yes, it can, mate. With trust deeds, ever since the sort of Commonwealth Bank nominees decision, we've been able to update them quite substantially. The only thing we probably can't change are default beneficiaries in terms of stamp duty. It just depends whether there's cash in the estate, cash in the trust. But we can include all the Bamford amendments, so we can stream income and the like. And we can, you know, give them all the modern attributes, give them wide powers. Most of the time, we just need to read the deed, though, and make sure that we're not restricted in any way from the variations that we make. So if you flash the deed down to us, mate, I'll be able to have a quick read of it and just let you know how far we can go in terms of changes. Just let you know what you really want done with it, and we can sort that out. And, yeah, typically without duty and without CGT.
Thanks, Steve. We've had a couple of questions that have come via email as well, and one of them relates to enduring powers of attorney and whether you need different enduring powers of attorney for different states, if perhaps you live in a border town or you're regularly travelling between different jurisdictions. So basically, each of the states will have their own laws that govern enduring powers of attorney and advance health directives. And most states do give recognition to documents that have been prepared in other states, but you do have to check the legislation and just you know, look at the detail to be satisfied that you're going to be covered in that other jurisdiction. For example, in Queensland, while we do recognise other states' enduring powers of attorney, that's only to the extent that the provisions of that enduring power of attorney could have been made here in Queensland. So if you spend a significant amount of time in a number of jurisdictions, an example of that might be we've got some clients that recently moved away from Queensland but are returning here for medical treatment. So we've suggested to them that it is a good idea to have an enduring power of attorney for each of those jurisdictions. And same with their advanced health directives. And another question that came via email, Steve, was just about if you've got property in different countries, how that will affect your will.
So look, we get a lot of people who've got an asset perhaps somewhere in Asia or something in the UK, and we're experts in Australian will law. So typically we'll do a will that deals with all your Australian assets, and it'll specifically say, hey, the assets that I have overseas, perhaps in Indonesia, I'm going to do an Indonesian will. So the next time that person's in Indonesia, or they'll start liaising with an expert will maker in Indonesia. They'll do a will for their Indonesian assets, they'll do a will for their American assets, they'll do a will for their UK assets, and each time they'll say, hey, I've done a will in the UK and it's going to be recognised in accordance with the UK law, but it doesn't in any way affect my will in Australia. It won't revoke my will in Australia. That way you're getting an expert in each jurisdiction to do the right thing. Some of our sort of old Italian clients who have inherited a property back in Italy, they're never going to get back to Italy. So they'll do a will here in Australia, and we'll do our best to get that registered over in Italy. In a lot of the civil law jurisdictions, though, estates pass, a minimum percentage must pass to their children, or minimum percentage must pass to their spouse, and there's only a small part of their estate which they're able to deal with under a will in any event.
Thanks, Steve. We've got a question, Kieran, about the tax obligations of a beneficiary of a self-managed or industry super fund. So I guess if they've received a death benefit when they're a beneficiary or under a binding nomination or under the will.
If your super is paid, your super can be paid to your spouse, your children, your executor, so your estate, or a dependent, which is a bit technical. If the super is paid directly to a spouse or via your will to a spouse, there's no death benefits tax. If it's paid from your super to, let's say, an adult child, not via the will, well then it's on the taxable component of your super, it's 15% plus the Medicare levy. So what's your Medicare levy at the moment? 2%, I think. They keep upping it. It'll probably be more the COVID levy soon. And if it's paid to your estate and then to adult children, then, or you know, to a trust that's for the benefit of adult children, then it's no Medicare levy, so it's just that 15%. Where it's paid to the super fund directly to those adult kids, it's a super fund that's got to pay that death benefits tax, so they take care of it. Where it's paid to the estate, it's the estate, so it's a legal personal representative who's got to make sure that they keep enough money in the estate to pay that death benefits tax, because the legal personal representative is responsible for that. And we've also got features in our will, so if super is paid to a testamentary trust, we make sure that there's no death benefits tax on that, whether it is for those infant kids or, you know, that spouse, you know, who's still alive. So we're saving on death benefits tax there.
Hey, Kieran, I might take over. You're just breaking up a little bit. The next question that was asked was, what are current death duty taxes? And Kieran was really just talking about those, the taxes on death benefits in super. So that's the really only death duty we have. If you leave a CGT asset to a charity under your will, then there's a death duty on that. And what happens is you're deemed to have sold that asset at market value on the date of your death. So your estate will end up paying capital gains tax. So if you want to leave an asset that's pregnant with capital gains to a charity, let us know and we'll get approval from the tax office, so you actually get a tax deduction. Your estate gets a tax deduction for leaving that asset to the charity under your will. Now, in terms of death duties, everyone knows that the government spent $135 billion on the COVID stimulus package. Hopefully it's not that expensive, but people have been suggesting, you know, how is the government going to pay for this? And they've been talking about death duties as one possibility. There's certainly been nothing coming out in any sort of formal way. We'll keep an eye on that. We'll keep you up to date if they are proposing to introduce some sort of a death duty. But hopefully the economy has a good bounce. There's plenty of GST revenue raised to pay off the stimulus package as time goes by.
Oh, and there's just one more question, Steve. This person's asking, they've got children and stepchildren and they've set up their will so that both the children and stepchildren will benefit, but they want to leave a significant asset to their children. Do they need to record this in a letter of wishes to explain why they want that asset to go to the children to avoid challenge by the stepchildren?
Yeah, look, ideally I'd do a letter of wishes, but perhaps even better is a statutory declaration just setting out the reasons why you're going to do it. And then it's something you probably should chat to any one of the panel today just why you're doing things, and we can fill you in a bit on how the family provision legislation works. In Queensland, unlike in New South Wales, stepchildren have got the right to challenge your will or estate. And they've got the same ability to challenge in the way that a normal child, one of your biological children, one of your adopted children can challenge. So we'll go through the machinations of how that challenge might work and just give you some our ideas of, you know, whether they're going to have a successful claim or whether it would be a non-successful claim. Typically, claims by adult children in family provision matters nowadays, they're not always going to be successful. In Victoria, they've introduced legislation that adult children over 25 who aren't disabled can't make a claim. And that's the way it's going. They want to give people more of a say under their will that they're not going to be challenged. Spouses have a much greater ability to make a claim. So look, yeah, have a stat deck, just setting out your reasons, and just have a chat to us about why you've done it. We'll let you know how that might happen. You may even want to bypass the will altogether and have the asset transferred through to your children now, during your lifetime, if we can save the duty in CGT so it happens and it's not going to be challenged.
Okay, I think that we've dealt with all of the questions now, and Steve's been busy answering some of those questions through the chat room. If anybody just wants to go through and have a look at those. So it's my job now to pick the winner of the wine. It was a tough call. I'm a bit disappointed that some people put anonymous messages in, so that meant you weren't eligible. So I think mainly because she did ask some great questions and also put in multiple questions, that Virginia Boniface will win our bottle of wine.
All right.
No.
Yep, we can hear you.
Okay, great. So thanks, Carol, and congratulations, Virginia. Thank you so much for joining us for the chat today. I'm really impressed with the amount of questions and feedback we were given. So yeah, good job to everybody. You know, welcome to the Merthyr Law team's households. And you know, thanks everyone for coming, and especially thanking all those presenters. And you know, any questions at all, you know, get in touch with any of us. And the one takeaway I'd really like for everyone today is, what's how do you get your will done? You just start. So you just book an appointment, and you know, we can help make it as least complicated as possible. And special thanks to Jacqui too. I've taken up all of your day off to do your assignment. So, you know, apologies for that, and thank you for joining us. Appreciate it. All right, thanks everybody. Hopefully there'll be a recording of this. We'll put out into the world at some point. We'll see how it goes. Thanks very much.
Thanks everyone. See you later.